So Mr. Solomon Okedara, I will not be reading his profile, saying that we have already done that already, prior to now, right? So Mr. Solomon Okedara is one of the mentors we're expecting in today's class. Okay, I can see that we're quite scanty in class today. Please, I would like for us to kindly try to send reminders into our subgroup to alert our other co-mentees that class has started, right? So that we can have more people joining on board. Right. So secondly, the mentor we already have in class, Mr. Emmanuel Ewere. Mr. Emmanuel is a legal professional and compliance specialist with a strong background in information technology, compliance, regulatory compliance, sustainability, and data protection. He holds a Master's of Law in Information Technology Law from the University of Tartu, Estonia, and a Master's of Business Administration from York St. John University, United Kingdom. Called to the Nigerian bar, Emmanuel has extensive experience advising clients on corporate governance, contract law, and compliance frameworks, particularly in the areas of GDPR and NDPR data protection law. Thank you so much, sir, for joining. We are happy to have you in today's session. And we are also expecting Mr. Ridwan Badmos. I'm not very certain of his presence today in today's session, but still all the same, as we have Mr. Emmanuel on board, we are sure that he'll be able to do due justice to the course pending when our other mentors will be able to join in. All right, so to kick off with us or to kick start the class for today, we would just like to hand over firstly to Mr. Emmanuel to give us his introduction into the topic. But you're welcome, sir. It's nice again having you in class.
Thank you very much, and it's my pleasure. And I want to apologize for not being available. And today, can you hear me?
Yes, we can hear you. Please, if you have your
Okay.
mic on mute, kindly do that.
Thank you once again. And today we'll be having I'll say eh, I'll say because I've seen the presentation, I've seen what we have done so far. So it will be more like a review of what we have actually studied. And I want to believe that with what you have done in your work so far, definitely you are familiar with what a data subject right is all about. So let's look at it from the Nigerian Data Protection Act 2023 context that has provided for certain rights available to a data subject. And these rights are not limited to the right to access, which is well elaborated and explained by the GDPR, and we know about the right to request, to correct, to delete, the right to portability. I would like to share. I'll keep more concentration to explain more on data portability and also the right to object processing, because I have this keen interest in these two, data portability and the right to object processing. So before I come to these two perfectly well, I'll just give a summary about what this rights entails generally. It's just to let you know that a data subject can confirm their data with a controller or with a processor. They can get confirmation about what data is being processed. And that data controller or data or a processor must provide relevant information as requested by the data subject in regards to what data is being processed, whether it is the personal data, whether it is a special category data. There must be a compliance to the request of a data subject. And this data subject must be informed about any category of the data that is being processed. That is centered more on the right to be informed. Now let's look at the right to access. A data subject should have access to their personal data at any given time. We should consider some examples. Um, I remember at some point I requested for a copy of my NIM my NIM ID, which was misplaced. I requested from NIMC, and they were like, I have to pay for it. At some point, I was quite worried that why should I be paying for my own data? But following some legal flow and understanding, I was able to get to the point that yes, at some point they could request for some payment, but I should have access to whatsoever I have requested for. So let's go to another one, the right to rectification, which is very important. Um, a data subject should be able to rectify their data, their information at every given time. Now, I'll share an example as well. In the last election, 2024 in the UK, sorry, not in Nigeria. So I had my postcode in my previous address, and I was yet to rectify this this data. And they kept sending mails to my previous address. I was furious at some point because I felt disenfranchised, but they brought to my attention that it was my responsibility to raise this rectification. So it is very important that a data subject should rectify their data at every given time. And it is your right to correct anything that is inaccurate, incomplete. Then the right to erasure, which I love calling the right to be forgotten. So if you are not interested in a controller having your data, you have the right to request that data to be deleted at every given circumstance. I don't want my data with you anymore. I am withdrawing my consent of you being in possession of my data. Kindly delete. So I said I will lay a little bit emphasis on portability, on data portability, because we've had series of questions on this particular part where a data subject will want their data to be transferred from one controller to another. And such transfer should be made in a form that it can be easily understood.
That's bad, man. Wọ́n lè rí nǹkan ìṣe ọ̀fẹ́ ìbùs. Ṣé wọ́n tún lò ó jáde?
Hi, Queen.
Sorry. I'll leave it.
Okay, we're back now. So we've had a lot of series where some controllers or processors will be kind of reluctant um, to share certain data as requested by the data subject because they they may feel that okay with sorry, just a minute. They may feel that okay, they're sharing certain, let's say they're sharing customers or they're trying to protect their business or so. But it is the right of a data subject that their data can be reused by another controller. And this can be transferred directly from one controller to another. This aspect is actually a very, very interesting part because if well elaborated, you will understand the controversies that surrounds it. I won't keep much, I won't place much time here because, oh, sorry. I'll just tell you a little bit on how it works. That a data subject can request let's use a company as the data controller to provide their personal data, and they're supposed to provide details, relevant details of who this data should be transferred to. So there is the requesting data, there is the receiving data, and there is a direct transfer. So when we talk about the requesting data, it is like a position where the data subject makes this request, or another controller through the consent, by the consent of the data subject, makes this request. And there is a receiving data where this data that is being sent must be in a readable format, must be in a clear and understandable format. And there is a direct transfer. How are you sending it? Are you sending it through, let's use normal, are you text message, email, Dix, whatever you do, but there should be a form of transfer. Remember, in the requesting data, it must be clearly stated what kind of data is required. And I would like to let you know that we have series of I'll just bring an example so that you will have this in the back of your mind. It's just like you requesting your institution, your let's say your university, to transfer or to issue out your transcript to another institution. That is the perfect example of data portability. We have had instances where a lot of universities will either delay or may end up not sending this transcript, and this has raised a lot of issues. Remember, as a data subject, you have a right to data portability. So where your institution, your university, refuses to transfer your transcripts at that given time when it is needed, when it is so needed, and they are failing to deliver, you can go to court to challenge this because you have a right to data portability. So there is also a limitation to this law. Remember, these laws, these rights are not absolute. I think I should just conclude at this point. These laws, remember, these rights are not absolute. There are limitations to how they can be applied. And I believe that after your presentation, we can have more conversation, deeper conversation about these rights and also their limitations. Thank you very much.
All right, thank you very much, Mr. Emmanuel, for your very wonderful introduction. We are happy that you were able to. We are happy that you were able to share with us, right, in these very few minutes, for the introduction to class. So please, we'll be heading over to have presentations from the mentees, right? So both group 1 and group 2. We would like to take your presentations now. So please, if we can, we'll be taking group 1's presentation firstly, and then we'll take that of group 2. So please, let's have group 1's presentation. Who do we have presenting for group 1? Okay, if the group presenter for group 1 is not ready, I think we can take group 2's presentations, right? We can take group 2's presentations first, while group 1 tries to sort out themselves as regards presentation. So group presenter for group 2, please, you can come on board and we would like to take your presentation.
Good evening, everyone. I am Sandra Okoma and I'll be presenting on behalf of Group 2. Mr. Dennis, please, I would like for you to help me share the screen.
All right.
Okay, so I'll just dive right into the first subtopic, that's data subject rights in Nigeria. Please, the next slide. Okay, what is data subject rights? Data subject rights are the legal rights created by data protection laws that individuals possess over their data usage. So in essence, data subject rights, these rights give data subjects a level of control over the processing of their data. Next slide, please. Data subject rights in Nigeria. So under Chapter VI of the Nigerian Data Protection Act 2023, data subjects have the following rights. I will explain briefly as I'm listing them out. The first one is the right to be informed. Data subjects have the right to know what personal data is being collected, why it is being collected, how long it will be stored, and who it will be shared with. This right also comes into play if the data controller or processor wants to use the data for additional purposes beyond the original reason for collecting it. And in such instance, the data subject can enforce their right to be informed and have control over how their data is used. The second one is the right to access. Data subjects have the right to request and access their data and obtain a copy of their personal data and supplementary information. This right finds expression under the principle of transparency. This is because transparency entails openness, and so the data controller or processor should be open enough to give access to data subjects when need be. And it's also important for me to state that this right gives rights to other rights that I would explain later, like the right to rectification, erasure, objection, and so on. Because if the data subject doesn't have access to these rights, it cannot rectify or erase or object to it. The third one is right to rectification. So if a data subject finds out that their personal data, which a data controller has, is not correct or is not complete or is outdated, they can request for it to be corrected. This is very important because accuracy is one of the fundamental principles of data processing. For example, if a person now gets married, obviously their marital status has changed from single to married, and possibly also their name has changed. So they can actually ask the organization or the data controller to reflect this change. The fourth one is the right to erasure, or the right to be forgotten, or the right to dereferencing. This right gives the data subject the power to demand for erasure or deletion of their personal data from the controller. This right is exercisable in certain situations, for example, where the data is no longer necessary with regards to the purpose for which it was collected, or where the data subject withdraws the consent upon which the processing is based, or where the personal data has been unlawfully processed. It's important for me to note that this right is not absolute, like our mentor has already said. This is because organizations or data controllers can refuse to request. They can refuse to grant the request on various grounds, especially if there's a legal obligation to do that. For example, banks, they have the legal obligation to retain transaction data for certain periods of time as mandated by the anti-money laundering law. Then we have the right to restrict processing. Data subjects can request that their organization limit the way that their personal data is being used. This is like an alternative to the right to erasure. And this can happen if the data subject is contesting the accuracy of their personal data, or when the individual no longer needs the information, but the organization needs it to establish or defend a legal claim. I'll give an example. Let's say a person named Ada is a former employee of a particular company and has requested for her personal data to be erased because she no longer works with that company. And let's say that Ada is suing that company for wrongful dismissal. The company has the legitimate claim to keep the data in order to establish or defend its legal claim. So instead of erasing it, they will restrict processing and the data will be retained, but it will be used for only the purpose for which is being retained. The next one is the right to object. If a company is using your personal data for certain purposes like marketing, research, etc., you have the right to object. And also, data subjects have absolute right when it comes to objecting to marketing purposes. The right to data portability. So this right encompasses 3 separate requests. The first one is that the data subject has the right to request that their data be given to them in a structured and machine-readable format without undue delay. The second one is that the data subject can transmit the data obtained in a readable format to another organization without hindrance. And the last is that the data subject can request for the data to be transmitted directly to another organization where it is technically. Sorry, are you saying something?
No, you can go ahead. Someone's mic was on mute.
Okay. So the last is that the data subject can request for the data to be transmitted directly to another organization where it is technically possible to do so. The next right is the right not to be subjected to automated decision making. This right essentially means that the data subject has the right to request human involvement in decisions based on automated processing like profiling that can actually affect them legally or significantly. For example, if a bank uses automated algorithms to determine the credit worthiness of any person, and because of that, they deny someone loan, the person can actually object to that. The next one is the right to withdraw consent. This right gives data subjects the right to withdraw their consent at any time. In fact, the Act provides that the data controller or processor should make withdrawal of consent as easy as it was obtained. And it's important to note that the data that has been processed before consent was withdrawn doesn't affect the legality of such data that has been processed. It's only anything done after the consent has been withdrawn that will be affected. The next one is the right to lodge a complaint. Data subjects have the right to file complaint to the NDPC where they feel like their rights have been infringed or they're not satisfied with the action or inactions of their data controller or processor. Now, please, can you move to the next slide? Now, I would like to add the additional rights under the General Application and Implementation Directive 2025. There are 2 additional rights. The right to notification of data breaches. So where a data breach affects an employee's personal data, for example, if surveillance footage is leaked and it affects a particular employee, the employer must notify the affected individual and the NDPC within 72 hours. And the last one is the right to lodge a complaint and standard notice to address grievance, also known as SNAG. So this SNAG mechanism allows employees to formally raise privacy concerns with their employer. This means that it allows for internal resolution of privacy issues first before it can now escalate to the NDPC if it's not resolved internally. Next slide, please. Okay, the legal framework for data subject rights in Nigeria. The first one is the Constitution of the Federal Republic of Nigeria. particularly rather, section 37 of the Constitution, which provides for right to privacy. And this section is so important because every law on data protection and privacy gains its legal basis from that right to privacy as enshrined in the Constitution. Then we have the Nigerian Data Protection Act, and it is the act that provides for these rights that we just mentioned, the right to access, rectification, and so on. Then we have the General Application and Implementation Directive, which also provides for the two additional rights that we mentioned. Next slide. Okay, the compliance challenges of data subjects' rights in Nigeria. I would explain as I'm listing it. The first one is limited awareness and education on data privacy and protection. Excuse me. So many Nigerians are not aware of their rights. Rights like right to access, rectification, and so on sound very foreign to people. Even principles like consent and withdrawal of consent, many people do not know about it. And sadly, you cannot protect or enforce what you don't know. Similarly, organizations like especially small and medium enterprises, often lack the knowledge of compliance requirements like appointing a data protection officer or even conducting a data protection impact assessment. And these things affect compliance, the level of compliance with regards to data subject rights. The second one is resource constraints and infrastructural gaps. Okay, so still using the example of businesses, especially small and medium enterprises. These businesses lack financial and technical resources to meet with the requirements of NDPA, like the requirements of encryption or secure processing system or cross-border transfer to secure jurisdiction and so on. And one could argue that the unreliable power supply in Nigeria is one of the major causes because these enterprises invest heavily on generator, diesel, high cost of electricity. Imagine a startup organization investing like 40% of their capital to electricity. Obviously, there'll be little or no money to go to other technical requirements like encryption. Also, when it comes to resource constraints, it can be seen in the NDPC. They are highly understaffed and underfunded, and this hinders nationwide audits as the NDPC relies on only 110 licensed data protection compliance organizations to support compliance in a country with over 200 million people in it. So the third one would be weak enforcement mechanism and penalties. The NDPA 2023 establishes the regulatory body, the NDPC, and gives it power to investigate breaches and enforce compliance. However, we can see that the NDPC struggles with enforcement. For example, last year in 2024, the NDPC handled over 4,000 compliance audit returns and 213 breach investigations. And they went unpunished. There was no clear punishment for them. Even there was an issue with the Nigerian Immigration Service where they were found to have published unauthorized passport data due to security loophole in their portal. And this thing went unaddressed, or will I say unpunished. And this signals weak enforcement mechanism, which also affects compliance in Nigeria. Then we also have the issue of lack of regular employee training. We can agree that data protection is relatively a new concept in Nigeria, and it is constantly evolving as there are new laws and regulatory frameworks being established. Therefore, there's need to ensure that employees of organizations are trained in data protection practices and understand their role in compliance. The last one is scarcity of judicial decision and case laws on data privacy violation. Nigerian legal system thrives on judicial precedents. Sadly, there are very few cases on data protection and privacy, and this has made it increasingly difficult for legal practitioners and judges to find authorities on which they can rely on when granting remedies to victims of data violation. Please, next slide. Okay, I'll go over to the cultural and social economic factors affecting data rights awareness. Social economic factors, the first one being low digital literacy and uneven internet penetration. A significant portion of Nigerian population are either not online at all, or they have minimal digital exposure. For example, those in rural areas rely on basic phones like Nokia Touchlight or the smaller phones rather than smartphones, and this limits their exposure to data protection concepts and hinder their ability to be aware of their rights. The second one is prioritization. Did I get that correctly? Prioritization of economic and physical rights over data privacy. Sorry. So in Nigeria, we know that there is high level of economic challenge like employment issues, inflation, insecurity, and so on. So people tend to often prioritize their immediate physical and economic well-being over concepts like data privacy. These rights are seen as luxury rights. For example, when people talk about other issues, which may not necessarily be pressing issues, but are still social issues that need to be discussed, you'd hear people say things along the lines of, instead of you to talk about insecurity or unemployment in Nigeria, we're talking about XYZ, or they'll say, how does this information affect the price of Gary? Even though it doesn't affect the price of Gary, but it's still something that needs to be talked about. And this is quite understandable because with the economic condition of Nigeria, people are more concerned with their economic well-being because sincerely, some issues are for those that have finished eating. The third one is weak enforcement and oversight mechanism. This, I've already kind of explained this one, but I'll just go over it again. So like I said, the NDPC has weak enforcement mechanism regarding breaches in violation of data protection and privacy. And because of this, we can see that most businesses and even government agencies are non-compliant because they feel like sanctions are rare and they will not be enforced. The next one is low awareness of data as an economic resource. Many Nigerians do not appreciate the fact that personal data fuels the digital economy. Personal data is rarely seen as an asset in Nigeria, and as a result, people sometimes unknowingly give out their data without knowledge of its economic or political power. For instance, this can be seen in location sharing on apps. Many apps will ask for consent to share location, and people will just agree without knowing the implication. Then let's go over to the cultural factors. The first one is cultural norms of sharing and communality. Nigerian culture values community and extended kinship, which often encourages openness with personal details. Asking someone's age, marital status, or financial condition is common and socially acceptable, so privacy norms are weak. The second one is prevalence of complicit silence. So even when people know that their data has been misused or compromised, example, unsolicited calls, they rarely challenge it. And this silence may come from distrust of institution or the mindset that nothing will change, or even lack of knowledge on enforcement. I would share a personal example. Sometime in 2020, I was always receiving calls from strange people, and these people would give me personal details about myself, like my name, the account, the bank I have an account with, some other personal details. And this call was really disturbing because it was coming in every day, like sometimes twice in a day. And I really felt like someone in that bank compromised with my personal details. So because of that, I just stopped using the account for a very long time. But I didn't even bother to take up the case because when I remember the long line at the customer service counter in that bank, it just discourages me and I feel like nothing will really be done. So in essence, what I'm trying to say is that people usually stay silent, and this affects the awareness, the level of awareness regarding data subject rights. Because if people spoke up more about these issues, there will be more awareness concerning it, and people will know that actions have repercussions or consequences. Then we have impact of social media. Social media has increased both data exposure and data rights awareness, and I'll explain. Social media has enabled people to freely share sensitive data online, things like location, family photos, lifestyle, like all these vlog, people that make vlog content. You can, see their surroundings, and these are personal data that ordinarily shouldn't be so accessible if not for social media. But at the same time, social media has also amplified awareness campaigns. I got to know about data protection and privacy online through social medias like LinkedIn, Instagram, and even WhatsApp. So in essence, social media is both a catalyst for awareness campaign and also data exposure. Please, next slide. Okay, case studies. I'll just read it out because it's self-explanatory. So we'll take the first case in Akosa Araka versus eCarts Internet Services Limited and Eat and Go Limited. A customer sued after his personal data given for a food order was later used for unsolicited marketing without consent. The court held that this breached the Nigerian Data Protection Act 2023 and Section 37 of the Constitution, which protects consent, purpose limitation, and the right to erasure. Jumia Food was cleared, but Domino's was found liable. The court ordered 3 million in damages, deletion of the applicant's data, and an end to unsolicited marketing. This decision reinforces that Nigerian courts actively enforce data subject rights. Next slide, please. Okay, this is the second case. Another recent case is the legal tussle between Boluwatife Sanya and a school which was instituted before the High Court of Oyo State after receiving an unsolicited SMS from the school advertising its admission program. The applicant never provided the school with his data, particularly his mobile number, and did not consent to any form of marketing communication. Hence, the SMS constitutes a violation of Section 24 and 25 of the Nigerian Data Protection Act 2023, which requires that personal data must be collected and processed lawfully, fairly, and with the data subjects informed consent. Additionally, Article 18 sub 1, paragraph A of the NDPA General Application and Implementation Directive 2025 explicitly provides that where personal data is processed for direct marketing, the consent of the data subject is the only basis on which such personal data may be processed. Next slide. Future trends and prospects for strengthening data subjects' rights. So why does this matter? This matters because if people do not trust that their rights are going to be protected, they will not use digital banking, e-commerce, or government services. Next slide, please. Key trends driving future changes. Okay, the first one is AI and data privacy complexity. AI magnifies privacy risks by making data less transparent, more automated, and harder to control. Strengthening data subject rights in Nigeria would therefore need to include AI-specific guidelines to protect individuals against exploitative data practices. The second one, technological advancement. Decentralized data management systems offer new ways to enhance data protection and user control over personal information. The third one, evolving global regulation. As international privacy laws evolve, Nigerian businesses must stay updated to maintain compliance and avoid penalties. And the fourth one, data localization. Governments worldwide, including Nigeria, are considering stricter data localization policies to protect citizens' data, which would impact cross-border data transfers. Next slide, please. Prospect for strengthening data subject rights. So the first one is stricter enforcement. So if we are going to strengthen data subject rights, we should have stricter enforcement of these rules when there are breaches. So this entails that the Nigerian Data Protection Commission should, try to enforce this. Like whenever someone violates any of these rights, ensure that they are punished. They don't go unpunished. This will help to strengthen, because people would be aware that, oh, if I do this, I'll not go scot-free, something like that. The second one is greater awareness campaigns. Like I said, people do not really know about data protection and their rights. So we should talk more about these things, because the more we speak up, the more people are aware of their rights. The third one is more court decision establishing precedents. So there should be more court decision, and this also relates to stronger enforcement, because when there are more court decision, when there are judicial precedents, people can rely on it when their rights are violated. The fourth one is resource allocation to necessary bodies. There is need for resource allocation, both human resource and infrastructure. There should be more people, more organizations in charge of compliance and all that. Then the last one is regular employee training. Like I say, data protection is relatively new and is also evolving. So there should be regular training to ensure that people stay abreast of legal new trends concerning data protection and privacy, and ensure compliance. Thank you. I think that's all. Thank you.
Thank you very much, Sandra, for your presentation. I think that presentation was very detailed, and you were able to explain all the concepts, including cases, which is commendable from both you and to your team. So well done to the team for putting together the presentation. So I don't know if Group 1 is ready now, right? Can we have Group 1's presentation? If the presenter for Group 1 is not present, can we have somebody within the group, right, step in and just try to help out with presentation? We will still take that, right? So please, let's have someone from Group 1 step in to make presentation on behalf of the can we all hear me? Okay, someone's trying to speak. Okay, we will not waste any time with this, right? Sorry about that, Mr. Emmanuel. I think I would want us to just hand over back to you for your feedback and thoughts that you would want us to share. There were quite a number of questions that were sent while presentations were made. So I would want us to maybe take out time, sir, to address those questions after you have given your feedback to the presentation and extra thoughts you would like to share. So back to you, Mr. Emmanuel. Hello, Mr. Emmanuel, are you with us, sir? Mr. Emmanuel, are you with us?
Hello, I'm here with you.
All right, sir. Sir, we had presentations from group two,
Yeah.
right? Presentations from group two, sir. We just want to get feedback from you as regards their presentations and also anything you would like to share. We have quite a number of questions that were sent in. I'll be posting those questions in the chat box very soon. So we'll be addressing that after your feedback, sir.
Okay, thank you very much once again. And I would like to say that the the presentation was fabulous, but the work was scanty. I expected more details, more more light on the Nigerian laws, and if possible, share any case because we have cases right now that borders on the abuse of data subjects' rights in Nigeria. So I expected much about Nigerian cases and even ongoing cases can also be applied as well. But generally, I would say that it can be done better. It can be done better. And since group one, they're not ready with their presentation, I can bring out some questions from the presentation as well, so that we can maybe have an in-depth understanding about this topic to give us more knowledge. Now, we look at Nigerian organizations. A lot of them are actually struggling to adapt and adopt to this whole trend of privacy and data protection. So, in this house, who can actually tell us which of these rights in particular do you think that Nigerian organizations are struggling to comply with? Hello, we have a lot of bright minds here, and I want to get feedback, or I'll start calling names. Let us be very sure that you participated in your group work and we are all together on the same page. So, or if you want me to take the question again, I can break it once again.
Sir, this Mohammed is saying the right to be erased.
Okay, maybe can you share a little light on this so that we can flow with your position, right to be erased? Very good answer. Like very good answer. Please share with us. Just give us a little light on why you chose this particular one.
Um, please, for the mentees, if you can hear us, right, and I assume you can, right, please let's try to cooperate and try to speak up in class, right? The session is not just a session to for you to come and listen, it's also for you to come and participate, right? So please let's have ongoing participation and contributions from all of you. Thank you. So please, Mr. Disu, you can just highlight based off of the question that Mr. Emmanuel asked.
This house is really quiet. This is not how we used to operate. I think we should unmute our mics so
Hello, can
that we
everyone hear me?
perfect this perfect. Please
Okay,
speak up
so
so that we
as
can
regards
interact.
as regards the right to be raised, I feel the reason why it is difficult for most companies to comply to the right to be raised is that it takes a lot of processing. A lot of processing goes into trying to edit a particular information in a particular field of data. So for instance, now, if I work in a particular firm for a while now and I've left the firm, and maybe according to the law, maybe after 6 months, they are supposed to delete my information. Sometimes, well, when some people leave a particular firm or leave a particular organization, because it is a large organization, they don't often have all the information that, okay, this person has left. Or for instance, now, if somebody gets married in a particular firm, they don't have all information. Some people don't update their information. So therefore, altering those information and trying to make it different is a little bit tasky.
Hmm. Hmm. Very, very, very smart. Very bright position. I like the way you marshaled it, and you you actually brought out some very vital things like the organization having stored it and going back to rectify or erase may actually cause them or bring about certain structural adjustments. May be reluctant. Excellent answer. Like this is very true. This is very practical about Nigerian organization, and I love the way you explained it. Do we have another person that can share one more with us? Disu, thank you very much for that brilliant, very brilliant explanation and point. Now I can confirm that one person is fully involved. He knows what we're doing and he is part of the class. So who else do we have, please?
Hello, sir. Good afternoon, sir.
Adedoyin. Very good. We have one more person. Adedoyin. Tell us, please.
Yes, sir. I believe that I think because many businesses share data with other companies for various
Right.
purposes. So, for instance, now a company usually shares companies usually share their employees' details with like HMO companies that they partner with. And so when a particular person or a data subject requests, okay, so for example, if if an employee leaves a particular organization or firm, and so they request for their data to be deleted, the original company is responsible for ensuring that all other third parties, such as the HMO, relating to this particular example I'm using, also delete it. But then it's usually hard because most company, after an employee leaves a particular organization or a firm, it's the accountability or the process for them to reach out to the other partner companies that they share their employees' data with. They don't usually go through that process, like Disu said. So it's usually more tasky for them. So they might delete it from their own records, but then to reach out to like partner companies that they share and their employee data with, they hardly do that. And so those third party companies usually still have employees the employees data information, and they might use it for marketing or some other things. But that's one of the um issue. And I think it's right. I'm referring to right of erasure as well too. I'm just giving an example to that.
Adedoyin, you're very valid. Very, very valid. It is part of the challenge as well. It is part of the challenges that organizations face after sharing it with other subsidiaries or other companies. They know that if they are to erase it, they have to go to the root of or third parties that they have shared it with as well. This could be a very long process, and most of them, they are not ready for this journey. So this is a very, very valid position as well. Thank you very much, Adedoyin. You are part of the class. You're smart and you're intelligent. Thank you very much. Let's get the last one, then we go to the next question. One more person. Tell us we have talked about these rights. These rights are so simple, but now let us be practical about it. What are those challenges that organizations face in regards to these rights? Tell us one of the rights they are struggling with.
Ayola, please, you can go ahead and answer rather.
Okay, good evening, sir. One other rights that I think organizations might have issue with complying with is the right of the data subjects to withdraw their consent. So I feel like this is more from a place of most organizations, they don't have proper privacy policies in place. And because of that, when a data subject gives consent to use their data in a certain way and then withdraws that consent later, they don't know how to implement and uphold or comply to this right of the data subject. And we've seen it from the case that group two we presented. That's in the case involving Domino and Jumia Foods with a customer. The customer actually withdrew the consent he gave um, Jumia Foods, but then they were not able to implement it because they do not have proper privacy policies in place. So I think that's one of the issues.
Ayola, you're smart. This is very good. This is very good. Now, I'd like to draw your attention to the fact that a lot of organizations in Nigeria, they don't employ competent brains. They don't employ capable hands to guide them on this process. They don't even have offices or persons they can, they can relate privacy and data protection issues with. So when they are faced with challenges like this, they'll misfire, they'll do the wrong thing. Or since they are not guided, they cannot be in accordance to the law. Thank you very much, Ayola. This is a very good position. Very smart again. This is to show that we have people that are part of this class, and I'm very impressed. I'm very impressed with your answer. Let's go to another question that will help us build the practicality of this topic. Now, do you think, let's use Nigeria as a case study. Do you think that the data subjects are truly aware of their rights as provided by the NDPA? And what do you think are those practices that can bring about an improvement in this system? Let's discuss again. Habib, Lawal, please let's discuss. Thank you.
Good evening. Thank you very much, sir.
Good
Hello?
evening. Wow. Thank you very
Okay,
much
thank you,
for
sir.
share with us your position.
Yes, sir. With regard to the question, what I will say is that what is actually the problem is lack of understanding or lack of knowledge about what data protection is. Many people know that, okay, they have right to privacy, but even this right to privacy, it will be hard to see people kind of litigating much over it or raising concern over it. So maybe perhaps it is because of the Africa setting or African mentality at the beginning that they don't see privacy as a fundamental right. Perhaps that is why people care less about their right to privacy. And this to me is what extends to their data privacy. So many people don't even have idea of what data privacy is, or knowing that they have one or there is any law that regulates their data or that protect their data. So they just see everything as, even from among the elites, people that have knowledge. I mean, people that have formal education. So you will see we see among them people that don't even know what data protection is all about. So I am thinking it is because of the very fabric of Africa society that is leading to this issue, that people that lead to when people not being aware of what their right is under the data protection.
Now, I understand your position clearly, and I would like you to, can you make some suggestions? How can this be solved? How can this be improved? How can this be made better?
Yes, sir. It is still about I recently saw from this data protection commission regarding advocacy or something like public enlightenment. And I also think I read news of NOA, National Orientation Agency, that they want to partner also with them. I believe this is going to be a very best way of addressing this kind of issue. If people are made aware or people are made know that they have a right, I believe with continuous engagement with people, people will realize this right and they will take action to protect it.
Continuous engagement. This is very brilliant. Continuous engagement. Thank you very much for that brilliant position. The discussion must continue. The awareness, the enlightenment must continue. So I like your point. Continuous engagement. Thank you very much. Do we have somebody else that can share with us? Do you
Yes.
think Nigerians are aware of their data right?
Good afternoon.
Okay. Okay, is Adedoyin again?
Yes,
Let's
sir.
take Anita first, then we'll come back to you, Adedoyin. I will definitely come back to you, Adedoyin.
Okay, all right, sir. Okay, sir.
Anita.
Yeah. Can you hear me, sir?
Hello.
Oh, can you hear me, sir?
Yes, we can hear you, Anita, very clear.
Yeah. For me, I feel like everything, apart from lack of understanding by Nigerians, I feel like another problem here is all about weak enforcement mechanisms and penalties. Like for example, now, okay, take the learned ones, the learned Nigerians amongst us. Sometimes it's not about the fact that they're learned and they know what data privacy is all about, but what are the mechanisms that are put in place by the governments, like by the agencies that foresee the data privacy and protection here? Because in a situation where I'm giving you my data to handle, and then you're not protecting it as, like in the way you're meant to protect, and then I report, and I'm not seeing anything coming out from it. Sometimes, and you know the way Nigeria is, sometimes it takes a long while for cases like that to be handled, especially in situations where there are a lot of, like, there are few or less judicial presidents by the judiciary on subject matters like this. So when you look at it like that, sometimes Nigerians, when you feel like a problem is getting long, for them it's better for them to just abandon it and move on with their lives rather than pursuing to the end of it. So I feel like that's one thing that that harms a lot when it comes to situations like this, because of lack of enforcement or weak enforcement and penalties that are being laid out by the government concerning these issues. Thank you.
Very smart, Anita. And you have made a very valid point. What do you think can be done to fix this issue?
Well, for me, things that can be done in these situations is more of like tightening penalties. For example, the legislators can put harsher punishments and penalties for this, which can the same energy that they always put towards other situations, they can do the same and try to employ people that work better to see that these situations are handled. For example, when it comes to the agency, the Nigeria Data Protection Agency, that they can actually employ better people, like competent people that can see to the end that, oh yes, that this thing have to be handled. But all in all, I feel like if something like this actually happens to, let me say, a top government official, I think that's even when they'll start taking it more serious. But because of, like, the situation that we always find ourselves in, that's why these things are handled this way. But it's all about them. It's not just about putting the penalties, it's about seeing to the end that the penalties are being carried out. And the same energy that they put towards foreign organizations when it comes to this, that they also do the same for Nigerians.
Exactly. That is the point, Anita. It is not just having these penalties, these books on ground. What is the implementation? Very, very brilliant idea and brilliant answer. Thank you very much. Let's go back to Adedoyin. Then we can now come to Ayola. Adedoyin, are you still there?
Yes, sir. Yes, sir. I'm there, sir.
Please share
Yes, sir.
with us. Share with us.
Yes, I think one of them is the recency of data protection and the law in itself. Data privacy as a concept is still new, and then the Nigerian Data Protection Act is also relatively new. While there was a previous one, but it's still a comprehensive statute that has not really been enforced for a long time. And so it might take time for people to really be aware of the legal provisions. And the other one is, I think, is literacy, because the NDPA can even be complex for lawyers like myself, talk less of ordinary Nigerians. And so it takes a lot for an ordinary person to understand the legal the way it is legally worded. And so a lot of people do not really understand the Data Protection Act. And so for the suggestion, like you asked the others, for the first one, that the fact that it is still data privacy is still a recent concept, and the NDP is still being a recent law as well. So I think what can be done is the NDPC can collaborate with media organization to try to maybe to launch like a campaign using television station and radio, especially in like local languages that the average Nigerian can understand their data rights, and also understand how they can go about enforcing it. And for the other one about the NDP and even data policies of an organization being complex, probably maybe the NDPC should maybe direct organization not to present their privacy policy, because I will not lie, still read like a company privacy policy of recent, and that's really like 5 times for me to really understand what he was saying. So probably maybe the NDPC can direct organizations to present their privacy policies in simple plain language that will be easily understand by the average person, rather than in like complex legal concepts that it even takes a while for even lawyers to understand. So for the first one, it's just maybe the NDPC seems like that's like the primary regulator regulating the NDPA in Nigeria should try and maybe launch a campaign with media houses to better educate Nigerians, and it should even be good for them to launch that campaign using native languages that other people can relate to, and then the other one maybe directing organizations to ensure that their privacy policy is easy and simple for an average person to understand.
Wow, this is a brilliant submission. Adedoyin again. Very, very good one. Thank you very much. Ayola, let's take you then. We'll go to the next question.
For me, and I agree with the first speaker that cultural factors are one of the biggest things that affect data privacy rights and right awareness in Nigeria, because most Nigerians, they don't see data privacy as data rights as something that they need to take very serious. When you compare it with normal social and economic rights. And my suggestion is not that far from what Adedoyin suggested, because there are times when I feel like one of the things that the NDPC should do is they should ensure that organizations take data privacy awareness. They should take it seriously as much as they take compliance, excuse me, as much as they take compliance with data privacy rights. So in as much as they're working towards complying with the provision of the Data Privacy Act, they should also ensure that they take data privacy awareness as serious as that. Because let's be honest, when you look at some of these organizations' websites, it's as if they're hiding those terms and conditions and privacy policies, as if they're hiding it. And even if you open it, I don't know how many people actually read those privacy policies. So
Right.
yes, making those things simple and easy to understand and not too complex. It's always so long and all of those things. So if the Data Privacy Commission mandates organizations to ensure that these privacy policies and when they mandate organizations to ensure that these privacy policies are simplified and easily accessible on their website, it creates more awareness for the average data subject.
Very brilliant. Very brilliant submission again. Thank you so much. We have people that are fully part of this class. Ayola, Adedoyin, Mohammed, you guys are super good, and I'm really impressed. Now, for the general house, I want you guys to understand that after this, you will be seen as an expert on this field. You will be seen as somebody that can advise on this particular issue of privacy and data protection. So, let us hear from you. What are those practical steps? A small business. I just really started my business. What are those practical steps I can take to ensure that I comply with the provisions of the NDPC? Let me rephrase the question again. As an expert on this particular field, you're being asked by a small business holder, how can I ensure I comply with the provisions of the NDPA? What would be your guide or your simple answer? Let's share some practical knowledge. Let's share. Come on, let's talk, house. Do we have okay this way again? Please tell us. Very good. Very good.
Okay, I think the most practical approach to it would be firstly appointing or employing a data compliance officer. Hello, sorry, hello?
Hello, we can hear you. Right.
Okay, so I think the first and the most important step would be first employing a data compliance officer. Someone that would help you organize and create a structure.
Hello. Sorry, is it my network? Okay, this way I can see you raising your hand.
Okay, do you have anybody ready to talk again?
Yes, sir.
Adedoyin, tell us. Very good.
Yes, sir. I mean, since you mentioned a small business, so I would understand that a small business might not necessarily have the provision for like a DPA. Maybe they can.
Okay.
So
Smart.
maybe the first thing they can do is to at least try and get like a consultancy from a data
Yeah.
protection officer or someone that is an expert, like all of us in this on this call. So and so what I would do, what I would explain to the person if I'm consulting for the person, because I would assume that as a small business, ideally, I don't really expect them to have provision for a DPO yet, but it should be in place as the business scales. So I would say that the first thing is to know what constitutes data for that business, because it is not every data. So if you are selling, a particular business does not come to mind right now, but it is not every data that you need. So, for instance, now if you're in the business of logistics, and your work is just to deliver things to people, you don't need their date of birth. What you need is just their address and maybe their phone number and maybe another person's phone number in case in case your workers want to deliver to them or you want to deliver to them and they are not around. So just know what constitutes data for your business. It is not every data that you need, and to also ensure that you adhere to NDPA, because it says that because I know the NDPA prescribes that you only need to get data from your customers that is necessary to that particular business. And I would say that the next one will be to implement I would say implement simple security measures, because when you get data, you need to have a way to secure them, maybe ensuring that they are stored on a Google Drive, or maybe some place else where you can use a two-factor authentication to ensure that it doesn't get leaked. And I would say the next thing would be to create a privacy policy, explaining to prospective client or customers in simple terms what data you're collecting from them, why you need it, and all of their rights, that they have right to erasure, they have right to withdraw their consent, and all of that. And then the next would be to plan for requests and incidents. So request meaning what we touched on earlier. Some people might request for their data to be erased. So you need to plan for that. And it's leading me back to what we discussed earlier. Organization needs to plan for requests for right of erasure or for people to withdraw. So once you prepare for those kind of things, it will be easier for you to not necessarily be a task, quote unquote, for you to go back and say, when there's measures already in place, it's just for you to just know how to erase those people's data that make the request. And so that's what I would advise a small business to do.
Very good at doing. I think you will have your first consultancy job after this training. Please reach out to me. Don't forget this. I will make
Okay, sir.
I will make a referral to you to
All
a
right,
small
sir.
business.
All right, sir.
Please
Thank you,
charge
sir.
the person as a small business owner.
All right, sir. I'm going to reach out to you definitely,
Please
sir.
do. Please
All right,
do.
sir.
We have brilliant minds here that are ready for this. So let's get one more person. Tell us what we do as a professional, as a consultant, as an expert on this. What will you guide an organization in Nigeria on the rights of a data subject? If you're being asked, we have an organization comes to you and like, we have a lot of data and belonging to lots of data subjects. How can we be in accordance to the law? Please just tell us what you advise. Generally, one word, just give us something that will show that you are fully aware. You are being trained on this particular field. Let's hear from another person. Don't tell me the others in this class are all sleeping.
Good evening, sir.
Sandra,
So to add,
thank you.
yes, to add to what they've said, I would advise a small business enterprise to always conduct what is called DPIA, that's Data Protection Impact Assessment. It will help them to identify and reduce risks associated with processing of data and to ensure compliance according to the law.
This is brilliant. This is a clear show of knowledge. Thank you very much, Sandra.
Thank you, sir.
Do we have more persons?
So, sir, you mentioned the question you just asked now, or the contribution from one of the participants now. Sorry, I couldn't get the name. So, sir, can you come again with the question? I'm trying to process it here, sir.
Okay. Let's say a small business comes to you and they need guide on how they can be in accordance to the NDPC. As an expert, what will be the first thing that you will say to them to make them know that you're competent for this?
All right, sir. I think if I get the question right, sir, I think what the first thing I will do is to make confirmation of what the business is about, so that one will be able to know which kind of data will be necessary for what the business is doing. So that one will be able to advise them in their small business, and complying with the NDPA might be demanding in terms of money. So I'll just kind of ask them what the business is about. Then that will be able to guide me to tailor, to give them advice on what data they will need to collect whenever they are whenever they are collecting data from people, so that they'll be able to stay within the NDPA. They'll be able to stay compliant. And also I'll be able to advise them on what they need to inform the data subject whenever they are collecting their data. I think these are the two things that are aside the issue of also informing them of how to store the data and the other thing that are associated with the data subject that are there.
Thank you, Lawal, for this. Now, having a very clear knowledge of the business is very important, but you should know that as an expert, one of the first things that is expected of you is to be able to guide on the privacy policy. As a new business, one of the first things they need to have on ground that you can guide on based on your expertise, based on your expertise, based on what you have learned, is to first of all guide them on having a privacy policy. And in this privacy policy, this is where you will be able to explain the rights of a data subject. This is where you'll be able to explain how the data will be collected, where the data will be stored, how it will be used, the third parties it will be transferred to, and the storage and the protective measures. So remember that you are not just learning this to put in your pocket. After this program, you will be seen, you will be addressed as an expert on this field. And if you're faced with the first challenge by a small business, remember that you explaining the rights of a data subject will be part of what will be contained in the privacy policy. I don't know if we all appreciate what I have just explained to you right now.
Yes, sir.
Very well. Thank you very much, Lawal, for your comments. That was thoughtful as well. Let me hand over back to the moderator and allow him to continue with the day. Thank you very much.
Thank you very much, Mr. Emmanuel. Thank you for everything that you have shared with us. It has it's been really nice hearing from you. Ask our mentees questions and drive the conversation on data subject rights. And also well done to the mentees for well done to the mentees also for your contributions to the discussion that we are taking. All right, we just want to go straight to questions and answers. All right, questions for our mentors. Sorry, I'm just trying to get a hold of it. We have some questions that were asked, and I want to read it out to Mr. Emmanuel to see what his thoughts on them are. All right, so the first question here is, what's upcoming trend in AI, blockchain, Web3, IoT, or biometrics do you think will most challenge data subjects' rights? That's the first question, sir.
Please, can you take the question again?
The question is, what upcoming trend in AI, blockchain, Web3, IoT, or biometrics do you think will most challenge data subjects' rights?
In fact, we know that with the development of with the fast growth of AI and innovations, we are actually heading to a state where, if not properly regulated, then not just data subjects to be affected. A lot will be in trouble. So looking at upcoming trends as asked, upcoming trends in AI that will challenge data subject rights. Which of the rights now? Let's look at these rights now. Which of the rights have possible challenge? Let's look at let's look at the right to erase. Imagine that imagine now that maybe an organization have been asked to erase data. Now you may erase data, but I want you to know that even after let's use our normal computer. Do you know that even after formatting your computer, information can be retrieved from it? Now, just imagine AI being in possession of any data, despite being deleted, formatted. As long as it is not overwritten, trust me, that data has not been erased. So we'll have a challenge with the right to erasure. Then let's look at transparency and the right to access. Now, we have many AI models, deepfake and others. Now, we have a lot of AI models that you can control what is actually the output, but you cannot control the back scene. In fact, this is the issue of the black box. It's very lengthy. I don't even know how to start explaining it now, but I'll tell you in the most simplest form so that you understand the issue of the black box. Now, the black box is, how will I make it very simple? Okay, a lot of programmers put in codes, and these codes actually bring about the outcome. But these programmers, they don't know what happens in between the outcome and the code. So this particular issue is actually one of the biggest issue in regards to AI. The issue of the black box, what happens behind the scene. Now, we have AI systems that are beginning to not just act based on codes, they are gradually developing themselves. So imagine a system that is now developing by itself. Will you be able to erase some data? No. If you have rectified some data, the original format will still be available there for future references. So AI system is actually one of the issues that will be challenging to the issue of right of a data subject, because AI as well can be biased, despite we seeing them as fantastic. We see them as the best thing that has happened. But trust me, there's a lot of issues that borders on transparency. And remember, I spoke about the black box. If we cannot deal with a lot of these issues that comes with the black box, what happens between the interval of the code and the outcome? What happens behind the scene? Then there's a lot for us to be scared about. Now, let's look at another issue, looking at the issue of automated decision making and profiling. We know that a lot of recruiters right now, in fact, they just allow AI systems to vet your CV and know if you're competent for the job, or if you'll be able to cross to the next stage of the interview. And this AI system can be biased as well, because the AI system may not be able to give a perfect or human. I think I'll explain this better in pidgin English. AI system no get sympathy, it don't get empathy. Let me go back to the original explanation. Cannot give that human attribute. So definitely we can have challenge there as well. Now let's look at another aspect that I think I know we will have challenge. That is in data security and prolification. Remember that you know that data right now is actually the new oil. It is big business for a lot of marketing companies, a lot of, in fact, for countries that are that are in love with spying, surveillance, and prognosing into other countries' and sovereignty. So, with the help of data, with the help of AI, trust me, there will be violation to a lot of rights of a data subject. Thank you very much, moderator. I don't know if I've done justice to this question.
Thank you very much, Mr. Emmanuel. You sure have, right? So I think we have a few other questions. I may be jumping over a few of them, seeing that it seems they have been particularly targeted during the questions while you were asking questions and the class, you were having an interactive session with the class. So the second question is, okay. The second question here is, how do you see Africa/Nigeria's data protection framework evolving compared to the EU or other regions?
Mr. Dennis, at the general house, on this particular note, I'll be more practical, I'll be honest, I'll be factual, because in this technology field that we're actually in right now, if you observe what is happening on the global stage, and I'll be sharing from experience, having gained valuable knowledge from the EU. So I would say that I am well grounded on issues relating to the GDPR, then embracing more knowledge from the UK GDPR as well. This has actually exposed me to what is actually obtainable out here, and having my little practice in Nigeria on these issues as well, I'll be able to share a little light on this. I want to let you know that what Africa, let me use Nigeria as a case study, what Nigeria is actually doing on this stage is more on copy and paste. They don't know the deliberations that has actually gone through before the outcome of certain laws, certain practices. So we just copy this, and paste without even knowing the implications, the enforcement, and the future of such legislations. And this is a very big challenge. This is a very big challenge. I will tell you the truth, day by day, robust discussion, public enlightenment, and measures are being put in place to expand the scope of data protection. But in Nigeria, using Nigeria as African case study, I see less effort being done by persons that are responsible for this. And I don't want to say the future is dull. I don't want to say the future will still be on copy and paste, because I believe that everyone here will be accountable as well. It is up to us now to infuse or to share this change, to bring in this change to the system, we should continue these discussions. Now, after this whole training, I want you to know that what next is for you to start engaging in conversations that will expand the scope and future of this topic. Then we know that the future of Africa and Nigeria is bright. And if you remember, we spoke about the challenges in Nigeria, and one amazing answer that came out from the house, the culture, the system of the country. So if we have a culture and a system that is still struggling to adapt and adopt to the system of privacy and data protection, then these are the discussions that we should be having, not going to discussions of e-privacy, because those discussions on e-privacy are way advanced, and they are not relevant to us at this moment. We need to come back to the grassroots and start resolving our issues. If we can have this discussion on how our culture and system can adapt and adopt the system of privacy and data protection and act adequately, then we are having the right discussion for the future. So we have a lot to do, and I believe that we can't just leave everything for the government. We can't just leave everything for those stakeholders. We are actually stakeholders in this field, and we can make our own meaningful contribution to make the future of Africa data privacy and protection very alive. Thank you very much.
Thank you so much, Mr. Emmanuel. Sorry, please, someone's mic is unmuted. Please, Elizabeth, you can go ahead and on. All right, so I think we'll be taking from the questions that we have here. I think we'll be taking one or two more questions, and we'll be calling it a day, right? So the third question we'll be taking here in practice, how do organizations in Nigeria handle conflicts between the NDPA and sector-specific law? Example, banking rules versus erasure requests.
This question is not really clear.
Okay, so if the members of the group can highlight the question and what they are trying to ask in specific, right? Elizabeth, please, can you go ahead and unmute your mic? Sorry, your mic is unmuted. Unmute your mic, I mean. All right, thank you. So if at all, like the people or the person who asked this question, right, wants to rephrase the question, please, you can go ahead and do that. But while we wait for that, is I would think the last question we'll be taking here is, so in your opinion, where are the biggest gaps between law and actual enforcement, that is with data privacy and protection rights in Nigeria?
This is another interesting one, and I'll be more practical about it than sharing theoretical analysis. Let me be more practical. Now, I want you to know that one big challenge in enforcement, no, let me start with having the law, having the regulation, and enforcement. First of all, I'll start with competent hands. Imagine lawyers like you and I that have built ourselves and made ourselves grounded on this field and knowledge. Instead of the system bringing us in to be able to administer the right approach of the law and bring about enforcement, they will prefer to bring in their cousins, their relatives, and those that are paying money to their private pockets. And at the end of the day, those incompetent hands will keep the system the same way it is. At the end of the day, the laws will be there, but who will be able to bring it to reality? Nobody. So the issue of enforcement will remain so loud if competent hands are not brought in. Then we have the issue of, should I say, we have this culture of, we like, how will I put it now? I want to make it very simple so that you will be able to relate with the way I want to say it. When something goes wrong and we're like, just leave them, just leave them, just leave. We don't take things. We don't take things. I just want you to really let me make it so simple to the point that, see, now what is applicable in the global stage is where there is a breach to a particular clause or a particular provision, the implementation and enforcement goes to the latter without any sentiment. But in our country, the way people think, the way people implement regulations and laws is so fused with sentiment. And that is really bad. Now, putting aside sentiment, we see the issue of corruption. A system built on corruption will definitely hijack and make implementation and enforcement a big challenge any day, anytime. It's up to you and I to do the right thing without sentiment, free from corruption, so that we can have our names written in the book of remembrance. There's a lot that I think is really, really wrong with implementation and enforcement in Nigeria. And I know that the issue is not the law, because the law is good, the regulation is good as well. But where we have the issue is the implementation and the enforcement, which I have shed a little light on why this issue will not go anytime soon. So I don't want to say the government anymore, because I feel that there's so much on our own decks, and if we can start from our own corner, a lot of things will be fixed. So let us start from any little opportunity that you have. Now, I asked a question about how will you advise a small business. That's the start point. That's where you start from. Now, a small business comes to you and they want to know what they can do to comply with the provisions of the NDPA. That's exactly how to start. If you cannot be able to, as a lawyer, as a consultant, I want you to know that, in fact, the first thing you're supposed to do when a client comes to you in that manner, first of all, send the person a retainership agreement. For the person to know that on this particular issue, I can't stop here. I can't just tell you A and it will end here. There is more I want to tell you, and in fact, more of it will come in the future. So can we agree that anytime you consult me on issues like this, there will be fees applicable. There will be this, there will be that. By so doing, you're already expressing your professionalism. Then you can now guide on what and what can be done. Remember, I told you that a small business, one of the first things you should be able to explain to the business owner is privacy policy. And you are the one to draft it. So it is not just learning about privacy and data protection. Also learn how to draft a very, very good privacy policy and how you can protect your client. It starts from your decks and my decks. If we can put things right, if we can get things right, with time, the system will be forced to adjust to what is right. That is my submission again. Thank you very much, moderator.
All right, thank you very much, sir, for hanging and helping us deal with question. I think I can say on behalf of myself and the mentees that we have really enjoyed this session, and we've had the opportunity to not just hear from you. We have also had the opportunity to dialogue and to share ideas and trade thoughts. And we truly appreciate the opportunity to do that, sir. So I think it's safe to say we have come to the end of today's class. There's something we're supposed to do lastly before we go, but unfortunately, I might not be able to come on my video because my location is quite very dark, right? Having very significant power issues right now. But please, for those who have some kind of lighting in their background, please that we can take a quick screen. Please let's try and do that right now. So that we can just call it safe. Thank you, Hadiza. Thank you, Sandra. Can we have more people turn on their videos, please? All right, thank you, Anita. Anita. All right, we are done with that. Well, to the mentees, please don't forget to share what you have learned in today's session. You can you can post what you've learned on a different social media platform. Share what you have gained from class. You can also do well to connect with Mr. Emmanuel, right? If you have further questions or things you would like to inquire from him, I think he's open for you to reach out to him. You can reach out to him on LinkedIn, right? So please let's try to keep the conversation going and ensure that we are pushing a narrative for the awareness of data protection rights in Nigeria and across, just generally across Africa also. Right. So thank you once again, Mr. Emmanuel, for taking out your time to being here with us. We really, really do appreciate your presence. And with us, we've come to the end of today's session. We are officially done with week 3 of the JIIPCC Mentorship and Internship Program for Data Privacy and Protection. For the mentees, see you all in week 4. Right. Please do well to schedule your time very well to ensure that you are present in class every time, right, so that you don't miss out on the important information being shared within the session. Thank you, everyone, and enjoy the rest of your evening. Good night.